Yes. We'll take
Just wait, just
wait.
Pastor, bill number 50. Comment remark.
Just wait. Because they're displacing some contract. Yes, Amit.
Disqualification, some of the other things also based.
Correct. There are two things. One, insofar as whether the work, the contract for whatever, continued during the pendency of the second term. Now, suppose the work is completed and only amount is paid, whether there would be conflict of interest is one. Now, let's assume there was a contract given to make the gutter, and they made the gutter within 6 months. And then after 2-3 years later, they were appointed to the panchayat or elected. And then what remained was only payment of bills. Then whether that would amount to a disqualification, one. Two, the second part, this is one part of it, that whether subsisting contract, etc. Second part is there must be an inquiry. And that inquiry, though 43A or 48(4) doesn't say, it only says inquiry, it has been held that because who is being displaced is an elected member, you have to hold it after giving principles of natural justice. In the sense, suppose there is an allegation of disqualification. You must put to him, this is the contract. This contract you have taken payment. This was made after you were elected. And in case any document is there, you must furnish copy, get his response, permit some summary inquiry. So on the first part, of course, we can see the record. Second part regarding summary inquiry, how do you say? They're saying it's only on the basis of written documents.
That's true, my lord. Kindly see, my lord, page number 31, my lord, for a moment, my lord.
Page number
31 of the paper book, my lord. First para itself is very clear.
page.
My lord, page number 31, my lord, annexure A. This is the disqualification order of the secretary. My lord, para 1, my lord. ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತಿ ರಾಯಚೂರು ಅವರ ದಿನಾಂಕ 24/2/2023 ವರದಿಯಲ್ಲಿ ರಾಯಚೂರು ಜಿಲ್ಲೆಯ ಮಾನ್ವಿ ತಾಲೂಕು ಸೋನ್ಸೋ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ವಿವಿಧ ಸಂಘಟನೆಗಳಿಂದ ದೂರುಗಳನ್ನು ಸ್ವೀಕೃತವಾಗಿದ್ದು, ಶ್ರೀಮತಿ ಕಾವೇರಿ ಗಂಡಾಸ್ ಗೋವಿಂದಪ್ಪ ಅಧ್ಯಕ್ಷರು ಉಟಕನೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಇವರು ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ 2022-23 ಸಾಲಿನ 15ನೇ ಹಣಕಾಸಿನ ಯೋಜನೆಯಡಿಯಲ್ಲಿ ಕೈಗೊಂಡ ವಿವಿಧ ಕಾಮಗಾರಿಗಳಿಗೆ ಸರ್ಕಾರದ ಮಾರ್ಗಸೂಚನೆಗಳನ್ನು ಉಲ್ಲೇಖಿಸಿ 14,47,357 ರೂಪಾಯಿಗಳನ್ನು ಕಾಮಗಾರಿಗಳನ್ನು ನಿರ್ವಹಿಸದೆ ಹಣ ದುರ್ಬಳಕೆ ಆಗಿರುತ್ತದೆ ಎಂದು ತಾಲೂಕು ಯೋಜನಾಧಿಕಾರಿ ಮತ್ತು ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಮಾನಿಯವರು ಜಂಟಿಯಲ್ಲಿ
What are the findings? What are the findings against Iram? Page number? Read.
ಸರ್ ಜಾಯಿಂಟ್ಲಿ ಎಂಕ್ವೈರಿ ಮಾಡಿದ್ದ
ಹಾಗೂ ಹಾಲಿ ಅಧ್ಯಕ್ಷರುಗಳು
ಜಾಯಿಂಟ್ ಎಂಕ್ವೈರಿ ಸರ್
ವಿವಿಧ ಕಾರಣಗಳಿಗೆ ವೋಚರ್ ಸಂಖ್ಯೆ 5 ವೋಚರ್ ಸಂಖ್ಯೆಗಳನ್ನು ಪಡೆದು ಕರ್ನಾಟಕ ಗ್ರಾಮ ಸ್ವರಾಜ್ ಮತ್ತು 43A5 ಅನ್ನು ಉಲ್ಲಂಘಿಸಿರುವ ಆರೋಪವು ಸಾಬೀತಾಗಿರುವುದರಿಂದ ಪ್ರಸ್ತುತ ಇವರು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷರಾಗಿರುವುದರಿಂದ 48(4) ಮತ್ತು 48(5) ಅನರ್ಹಗೊಳಿಸಿ 43A ಸದಸ್ಯತ್ವ ಸ್ಥಾನದಿಂದ ತೆಗೆದುಹಾಕಲು 12A ಮುಂದಿನ 6 ವರ್ಷಗಳ ಕಾಲ ಚುನಾವಣೆ ಇಲ್ಲದಂತೆ ಅನರ್ಹಗೊಳಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. So far as 43A and 12 is concerned, that may not already the current significance granted interim order. Now what is remaining is 48(4). 48(4) is removal from the post of Adhyaksha also. Now I am saved to become the continue as a member of the Panchayat. Under 48(4), as you know, which has not been appealed by the government, which says that an inquiry, in the sense the inquiry officer's statement should be recorded and should be given an opportunity to that process. This is the law. Now, nonetheless, the allegation is not that I have continued with the work. There is no allegation that there is any direct or indirect connection between me and the contract given to my son. In fact, what I have stated in the objection is that my son has separated from me and is living separately. That is another issue on which the inquiry officer has not given any finding on that. Submission which I have made before the objection. Kindly come to paragraph number 10.
Read.
From paragraph 10, may be true that the allegations
Reading judgment.
as regard to financial irregularities and inquiry is also responsible to ascertain the genuineness of the allegation. The document based on which one both particular bank statements of the Gram Panchayat speaks that the petitioner has drawn the money in his Gram Panchayat account, which is per se illegal. It is also true that the inspection report submitted by the Panchayat development officer discloses about financial irregularities submitted by the petitioner. But the question would be as to whether the state government can hold the person incapable of performing duties or persistently resist in performing duties, stands an opportunity of affording hearing to him. The intention of the legislature is clear that in section 43A of the Act, it is provided that after giving him an opportunity of being heard and after such inquiry as being necessary, action can be taken. Whereas in section 48(4) of the Act, an Adhyaksha shall after an opportunity is afforded for hearing him and if necessary after obtaining a report from the Kalaburagi and considering the same with removal from the office. Thus, affording an opportunity for hearing the person affected is mandating. It is not in dispute that no personal hearing was provided to the petitioner. Merely issuing so-called notice and considering the reply would not be sufficient to take drastic punitive action, such as removing an elected representative from the post of Adhyaksha or Upadhyaksha and also from the membership from the Gram Panchayat, unless the inquiry is held recording the statements of the petitioner by the inquiry officer under the proceedings initiated. In the judgment relied upon by the learned government advocate, inquiry was held and the statement of the affected person was recorded. Similarly, in the judgment relied upon by the Supreme Court petitioner also, inquiry was conducted and statements were recorded. In light of these judgments, it is clear that according to an opportunity of hearing to the affected person has to be strictly adhered to. Any order passed in violation of the same would be illegal and unjustified. Now, my lord will see the allegation against this appellant is that some vouchers are not approved in the area during her hearing. Now, there is no statement recorded of this appellant nor the statement of the inquiry officer. Inquiry officer saying that yes, the only statement given in the inquiry is that there are vouchers which are released. There is absolutely no mention that I have continued with the work till today or that I have been executed. Now, my lord, kindly see this that my disqualification in the very same order has been stayed partly. Now, I will not be continued as Adhyaksha. Well, I will be continuing as the member of the council. That will be an anomaly also where I am permitted by the interim order to continue as a member of the council, the Gram Panchayat. But to not act as Adhyaksha would be more punitive than the interim order. Therefore, my respect to submission. There be an interim order of the order that is A.
The work was completed before the term.
That was I am not able to ascertain whether it was completed or not because the allegation only speaks about
vouchers.
There is nothing related to works. And what is alleged against the former Adhyaksha is that certain
No, do we have a copy of the charge or in this, let us see what the charge.
But kindly come to page 32.
Yes.
It starts at page 31 only. Last paragraph of page 31. It's the 22-23 ಸಾಲಿನ ಕಾನೂನುಗಳ ನಂತರಾಂಶದಲ್ಲಿ ಪಾವತಿಯ ಹಣದ ಬಗ್ಗೆ ಮತ್ತು ಕಾಮಗಾರಿಯ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲಾತಿ ಕಡತಗಳು ಇರುವುದಿಲ್ಲ. ಆದರೆ ಅಧ್ಯಕ್ಷ ಮತ್ತು ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಇವರ ಸಮ್ಮುಖದಲ್ಲಿ ಹಣವನ್ನು ವೆಂಡರ್ಗೆ ಪಾವತಿಯಾಗಿರುತ್ತದೆ ಮತ್ತು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸದಸ್ಯರಾದ ಶ್ರೀಮತಿ ಹಿರಮಲತಾ ಅಮರಪ್ಪ ಸಾಬಿ ಕಡ್ಕಲ್ ಇವರ ಮಗನಾದ ಶ್ರೀ ನಾಗರಾಜ್ ಗುತ್ತೇದಾರ್ ವೆಂಡರ್ ಅವರ ಖಾತೆಗೆ ವೌಚರ್ 15 20 38 40 ರವರೆಗಿನ ಒಟ್ಟಾರೆ 2,48,668 ರೂಪಾಯಿಗಳನ್ನು ಪಾವತಿಸಿರುವುದು ದಾಖಲೆಗಳಿಂದ ಕಂಡು ಬಂದಿರುತ್ತದೆ ಎಂದು ಶ್ರೀಮತಿ ಕಾವೇರಿ ಗಂಡ ಗೋವಿಂದಪ್ಪ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಶ್ರೀಮತಿ ಹಿರಮಲತಾ ಅವರ ಸದಸ್ಯರು ಇವರ ವಿರುದ್ಧ ವಿಚಾರಣೆ ನಡೆಸಿ ವರದಿ ಸಲ್ಲಿಸಲು ಪ್ರಾದೇಶಿಕ ಆಯುಕ್ತರನ್ನು ಕೋರಿರುತ್ತಾರೆ. ಅದರಂತೆ ಪ್ರಾದೇಶಿಕ ಆಯುಕ್ತ ಮೇಲ್ಕಟ್ಟೆದಾರರಿಗೆ ವಿವಿಧ ದಿನಾಂಕಗಳನ್ನು ವಿಚಾರಣೆಗೆ ನೋಟಿಸ್ ಜಾರಿಗೊಳಿಸಿ ವಿಚಾರಣೆ ಕೈಗೊಂಡಿರುತ್ತಾರೆ. ಉಭಯ ಎದುರುದಾರರು ಲಿಖಿತ ಹೇಳಿಕೆ ಮತ್ತು ಮೌಖಿಕ ಹೇಳಿಕೆಗಳನ್ನು ಆಲಿಸಿ.
Now you just go to page 34, last paragraph. There.
ಎದುರುದಾರರು ಆಗ ಶ್ರೀಮತಿ ಹಿರಮಗಂಡ ಅಮರಪ್ಪರವರ ಪರವಾಗಿ ಹಾಜರಿದ್ದ ವಕೀಲರು ಹಿರಮಗಂಡ ಅಮರಪ್ಪ ಪಂಚಾಯತಿಯಲ್ಲಿ ಸದಸ್ಯರಾಗಿದ್ದಾಗ ಜರುಗಿರುವ ಪ್ರಕರಣವಾಗಿದ್ದು ಸದರಿ ಅವಧಿಯಲ್ಲಿ ಅಧ್ಯಕ್ಷರಾಗಿರುವುದಿಲ್ಲವೆಂದು ಮತ್ತು ತಾಯಿ ಮಗ ಇಬ್ಬರು ಬೇರೆ ಬೇರೆಯಾಗಿ ವಾಸವಾಗಿರುತ್ತಾರೆಂದು, ಅಲ್ಲದೆ ಅವರ ಮಗನಿಗೆ ಕಾಮಗಾರಿಯನ್ನು ಹಂಚಿಕೆ ಮಾಡಲು ಮತ್ತು ಹಣ ಮಂಜೂರಾತಿಗಾಗಿ ಯಾವುದೇ ಶಿಫಾರಸು ಮಾಡಿರುವುದಿಲ್ಲವೆಂದು ಮೌಖಿಕವಾಗಿ ಮಂಡಿಸುತ್ತಾರೆ. ಇಲಾಖೆಯ ಅಧಿಕಾರಿಗಳು ಸಹ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ವಾದ ಮಂಡಿಸುತ್ತಾರೆ. ನ್ಯಾಯಿಕ ನ್ಯಾಯಾಲಯವು ವಿಚಾರಣೆಯಲ್ಲಿ ಹಾಜರಿದ್ದ ಎದುರುದಾರರ ಇಲಾಖೆಯ ಅಧಿಕಾರಿಗಳಿಗೆ ಪಾಠಿಸವಾಗಿ ಇದೆ ಎಂದು ಹೇಳಲಾಗಿ ಮುಂದುವರೆಗೂ
ಏಜೆನ್ಸಿ ಅದ ನಾಗರಾಜ್ ಏಜೆನ್ಸಿ ಅಂತ ಒಂದು 22 ಇದೆಲ್ಲ ದಿನ
ಸದಸ್ಯರ ಪರವಾಗಿ ತಮ್ಮ ಲಿಖಿತವಾದವನ್ನು ಮಂಡಿಸುತ್ತಾರೆ. ಮೇಲಿನ ಎಲ್ಲಾ ವಾದ ಪ್ರತಿವಾದಗಳನ್ನು ಆಲಿಸಿ ಕಡತದಲ್ಲಿ ಈ ಕೆಳಕಟ್ಟ ದಾಖಲೆಗಳನ್ನು ಆಲಿಸಿ ನ್ಯಾಯಾಲಯವು ಪರಿಶೀಲಿಸಿದೆ.
We'll consider.
Yes, we'll get the my lord.
Correct. Now it's only against.
But kindly see, now this is the Xerox copy, my lord. Original document.
What we are saying, we are not entering into the merits. We'll have to decide it.
Yes,
once we decide, either we uphold it or no. But now this is only against the interim order.
That's why, my lord.
So the only no, we can't. Anything we pass in detail will prejudice the main proceeding pending before the single judge.
That's true, my lord.
Now, single judge in his discretion has said stay of disqualification. So they're saying the remaining part of the interim order ought to have been considered, is what they're saying. That's all we are on that.
Nothing will.
Now, for instance, if there was no interim order on disqualification, then we would have heard you. No, partial interim order is granted.
Nothing will be happen. First matter, your lordship will top up the list only, my lord, because some of the documents is available, but Xerox copies.
No, that's on merits.
We don't. I will convince you, lordship, my lord. Even, my lord, in the name of the lord, our son is also notified this in the inquiry. How much amount is also received? It is there. That's why, my lord, I'll get the original records and I'll make the submission.
Correct. That you have to place before the single judge.
That is tomorrow only. Nothing will be happen. First matter only, my lord, and nothing will happen.
If we were to reject and pass a reasoned order, it will prejudice the proceeding.
But your lordship, tomorrow will dispose of. This is only interim order, my lord. That is only interim order, my lord. That is true, my lord. Even you also direct the other councils, my lord, to take notice. Direct to take notice, my lord. That will dispose of it, sir.
I have passed an order on similar lines. Just check. I have also given little more detail of displacing of how inquiry should be held after reiterating this, because he's an elected member, and that inquiry means inquiry. It cannot be only written reply and show cause. Just check it out. Relist the matter tomorrow.
Please. Lordship may direct me to take notice for respondent 1 and 2, my lord. And
accepts notice for respondent
1 and 2, my lord.
1 and 2.
2. And Mr. Gauri Kausapur was appearing for the, my lord, Jilla Panchayat, my lord.
For the
Jilla Panchayat. Respondent number
chief executive officer.
234. 234. my lord.
So and so.
My lord.
Undertakes to.
I filed a single judgment proposed respondent implying proposed respondent. my lord. Respondent numbers.
That's okay. Now 234.
234, my lord. Last one is the complaint, that is a private party, my lord.
No, that we'll see. We'll have it tomorrow. We'll see.
Yes, my lord.
Read this tomorrow. Now, no full hearing tomorrow.
Nothing. Tomorrow itself, dispose of this matter itself.
ರಾತ್ರಿ ಕೊಟ್ಬಿಟ್ರೆ ರಾತ್ರಿ ಎಲ್ಲ ರಿಸರ್ಚ್ ಆಗುತ್ತೆ. Only on the point of the nature of inquiry, one you point out. Now merits, there may be a case, there may not be a case. On the manner of an inquiry, you get on the point. We'll see.
Please.
I don't want to enter into the merits because anything we say will prejudice the proceedings. Yes. How much more term is there? Yes. Yes.
Records for a second.
Yes. Pass over. Huh? Yeah. ಅದಕ್ಕೆ ಆಯ್ತು ತೋಡು
Number 25, AG.
Additional Advocate General is on line, my lord.
Please, my lord.
Yes, yes. I'll dictate it immediately after the criminal matter. Criminal appeal is there. Afterwards, I'll dictate it. Just
Please, please.
Number 27, government advocate.
This is, my lord, Additional Advocate General is appearing, my lord. This.
Yeah.
My lords, in this case, I placed a short note on record, my lords. Lords, to
This is Patwari case. my lord.
Note.
Judgment.
where interest has been ordered by the tribunal, my lords. After it was held that interest is, my lords, this is a case which has some history. Lords, the village officers, my lords, prior to the abolition of Mysore Village Officers Act, was the office was a hereditary office.
Anyhow, you are only on the interest.
Only on the interest, my lords. We have actually paid all the pensionary benefits have been given, my lords. In fact, despite the fact that the judgment of the tribunal in this honorable court was against, contrary to the three judgments delivered by the honorable apex court between the same parties. It was hit by res judicata, my lord, even judicial discipline, all those things we put at rest on taking a humanitarian consideration, my lord, view, lenient view, we decided to pay them pensionary benefit. After that, they again go back to the tribunal and obtain an order for interest, my lords. It is only that part, my lords, which we have grievance with, and it's to be stayed, my lords, because they filed a contempt petition before the tribunal, and in some cases, I'm told that our hands were forced to comply with the order also. But the pensioners themselves are no more; their dependents.
What is this post? What is the work?
Patwari, my lords, similar to what a village accountant or village accountant would, the work rendered by a village accountant today.
Like a Shanbog, is it?
Shanbogs, yes, ma'am. They are all
Shanbog.
Shanbogs. Shanberg.
Shanberg, my lord. Honorary, they were
And works in some
discharging
places.
their duty, my lord.
Light of two. Only the rest has been paid, only
Yes,
interest.
only interest, my
Only
lord.
interest. It's only on interest, my lords.
Light of the contentions advanced. Learned Additional Advocate General Shri N.Y. Vijay Kumar. There will be stay of the order of the tribunal insofar as the direction of payment of 12% interest
Please.
amount due from date of retirement / termination till date of payment. Full stop. It is submitted that the principal amount due, that the entitlement of the applicants has been satisfied,
That
and
is
what
fine.
remains is only the payment of interest as ordered. Such
Please.
submission is taken note of. Emergent notice to the respondent.
Great.
Much obliged.
I appear for the petitioner, my lord. Lord, the 4 annual increments penalty was imposed against the petitioner. That was questioned before the tribunal, my lord. The tribunal lord dismissed my application as per Annexure A, page 14, my lord. The facts is, my lord, the complaint against the PDO and the applicant is the assistant engineer, my lord, is a nodal officer to Gram Panchayat. There is some irregularities in respect of Narega works. Insofar as the inquiry report is concerned, no loss caused to the petitioner.
Now you take out notice.
Please,
It's an
please,
order of June 22.
please, please. I am not for an
Page,
interim order because already
GA,
penalty order was
PW. It appears your client is even otherwise well placed. Yes, Mallikarjun. Correct, huh?
Yes.
Fast title was this. GA accepts notice of respondent 1 and 2. Lokayukta.
Subhas Mallapur.
Subhash Mallapur. Direct to accept notice for respondent number 3. Yes. Same PWD minor irrigation.
Number 29, 840.
Yes. Yeah.
Specialist pediatrician. CH-2. But this order is usually passed at page 24. Why they not corresponding to the district health? Page 24. So this is the order of the review.
From Jevargi to Kalaburagi.
That is from Jevargi to Kamla.
To Kamlapur. How far is it?
Around 60, 70.
Huh.
Now, Lord, here, Lord, this is an order saying the deputation. Lord, this was challenged before the tribunal. Lord, my tribunal has been also rejected my case. And Lord, here, Lord, the third respondent, Lord, in the first place, Lord, is not complained to pass an order of deputation.
Okay, now where are you working now?
I'm working, Lord, I have, Lord, immediately I have advised the order. Immediately, Lord, I'm working in Kamla, where I have
You're
been
working.
transferred. And Lord, here there was no expense as stated, Lord, and
Let us see. Let you take out note.
Lord, here, Nyaya is one something. Thank you. Lord, here, Lord, 10th month, Lord, this order was passed. By the Lord, the third respondent. Lord, the third respondent is the DHO. But the DHO cannot, there can be a deputation between the two departments. There cannot be a deputation within the same place, same district. And that too, the DHO cannot pass such a, government alone has the power to make deputations. That too, by the consent of the employee and by the tripartite agreement of the three parties. So that is it. And now, where have been transferred, there is no post of the specialist accreditation at all. Have been transferred to PSC, Public Health Center.
What are you? You are a pediatrician.
Specialist.
Ah.
And here, none of the ingredients of the
No, that we'll see. So you are saying you now what are you doing? From in the Jevargi office, you are working as pediatrician.
Specialist.
There is a post of pediatrician. There is.
And it is a CX. Here, where have been transferred, there is no post at all. It is a PSC. And that too, when the third respondent, he is not completely passed out any deputation orders. That too, within the same district. It is with the government order. And even
Just 1 minute. Now, in case of a pediatrician, can he be posted as a medical officer in a PHC or no?
No.
Only. No, I'm just trying to understand.
He cannot,
He has to be posted only as pediatrician.
Yes, I know. There, PLC, there are specific sanction posts. Only against those posts, those persons.
No, correct. What I'm asking, suppose you are a pediatrician here. Can you be posted as a general practitioner? No.
No.
It has to be only as a pediatrician.
Yes.
And here in the PHC, there is no pediatrician
There is
post.
no petition and I cannot claim a salary also.
Why?
Because there are no sanction posts in that particular case of accreditation.
Pediatrician.
So I cannot claim my salary also.
No,
This
it
is
is
an arbitrary order passed by the correspondent. And there are 2011 medical books. It is clear as it should be through counseling only. And counseling only, and even if it is transferred outside the counseling process, that particular officer should be held responsible. So that is very much clear in the 2000.
We'll have it on Monday. You get instruction. Now, just see. Suppose you are a domain expert pediatrician. You can't put him as a general.
not, we are not transferred, my lord. That is annexure A3, my lord.
Deputation.
We deputation.
Yes, my lord. Pediatrician cannot be deputed to look after adults.
Because, my lord, there is very much is necessary for that is the reason, my lord, we
It
transfer.
becomes like Urdu and
I'll get
English.
the instruction.
No, it becomes like Urdu and English. Pediatrician means you can't allow him to.
I will get the instruction, my lord, on Monday.
And if you have difficulty, you must engage somebody
Please.
on contract basis. Gynecologist. Monday.
He is
Monday
already
we'll
relieved. He's
Monday
already
we'll
relieved.
We'll consider on Monday. GA accepts notice for respondents 1, 2, 3. There's nobody else. This matter in same stage on Monday.
Please.
Now, whatever difficulties you have, you can't employ a person in a place where he's not competent to.
We'll get the
As a
instruction.
pediatrician, no objection.
Please.
I think too. Hearing out. Hearing out. The criminal appeal for test. I think criminal appeal. Direct criminal appeal.
Number 47, Syed Mastan.
We may be discharging the board except one matter we are going to dictate. Anybody else, you can come and take dates from the court office.
39, my lord, there is some urgency. MFA filed, and my marriageable age is expiring, and my lord, the order is passed without consideration of legal issues. It's an urgent matter. Lordships have not had agreed to hear this matter today, my lord.
No. Some interim protection is granted or no?
No, my lord. No. The divorce. I am the petitioner before the family court, nandu reject agide.
No, correct. Then that has to be heard, isn't it? How we can
Correct.
dispose it on admission stage?
Yes, last time, my lord, it had come up in the admission stage. My learned friend filed wakalat.
No, no, correct. But I'm saying we can't dispose it off at admission stage. We'll fix a date and then let us.
Some urgency. I'm at your lordship's hands, my lord. Some urgency in that.
Not on this part. Only 1 week we have. We have some other parted matters. Relist the matter.
Can I take a chance, my lord, next week?
So we'll give a date, March 1st. 6th of March. 6th of March.
Great.
My lord, one kind submission, my lord. Serial number 30. My lord,
Yes.
my lord, it may be any convenient date, my lord. Last week only I filed, my lord, wakalat. My lord, getting, my lord, it's on liability aspect, my lord. So any
Yes,
convenient date. Please.
We hear it.
Publish.
Relist in the second week of March.
Published. Much.
Serial number
38. They're trying. You are the landowner. Huh? You suffered a decree for specific performance.
I'm for the caveator.
Huh.
Last time also I made a mention. There are two suits. One is for declaration and one is for specific performance. They have also lost the suit for declaration. Half portion of the property is already been sold in our favor, and half portion was agreed in favor of to be by virtue of agreement of sale. They filed suit for declaration for cancellation.
Correct. So far as declaration, that now.
The suit boundaries are different, my lords.
No, 1 minute. Last time we asked you specifically.
Please, my lords.
That you have filed an appeal against the.
Please, my lord. The pecuniary jurisdiction of the
suit.
Please, my lords. We have filed, my lords. The pecuniary jurisdiction of that is coming to the.
District court.
No, my lords. Court hall 5, single bench, my lords. Please, my
You
lords.
have filed.
Then
My
both matter could be heard by the very same court because both matters were heard.
It is based only on agreement.
Please, my
It is
lords.
based on title.
The boundaries are also different, my lords.
No, that we'll see. Okay, in this, they will not. Now we'll only stay it. We'll hear it.
Please, my lords.
We'll stay it. We'll hear it.
Insofar as
Specific performance.
Please, my lords.
We'll stay it. We'll hear it.
anyhow, my lord, I cannot alienate the property. My lord, the remaining half portion, they are in possession of the property.
Correct.
Nothing is
now,
more.
Suppose you undertake not to precipitate any execution proceeding, there ends the matter.
We have not, my lord, done anything, my lord, till today. My lord, no execution, nor there is any
My lords,
notice.
there is an anticipation. Kindly stay.
Merely anticipation bad.
In light of the contentions raised, there would be stay of the judgment and decree in OS number so and so. Appeal is admitted.
My lord, one humble request. If appeal is admitted, my lord, it will take more 3 to 4 years. Let records may be called for, my lord, it will be the 2025 matter, my lord.
Great. How we can dispose of appeal in admission stage?
Records may be called for.
The remaining are waiting in the queue. So
let records may be called for instead of admitting the matter.
First appeal it is. It has to be admitted.
My lords, memo for handling.
Yes, admitted. Paper books to be filed within 6 weeks.
My formal objection. Caveat
Third counsel for the caveator.
Otherwise, client will feel
has contended that the appellant has lost the suit for declaration with respect to half portion of the property. Third counsel for the appellant submits that the said judgment and decree has been challenged separately.
Please, my lords.
Separately. Yes.
Let's serial number 33.
Serial number
33, my lord.
Yes.
Suit is for declaration, injunction, and rectification of ROR. Suit is partly decreed in favor of plaintiff. Kindly.
We'll have it tomorrow. Let us.
Please, ma'am.
We'll have it tomorrow. Any objection? What status quo can we say or what?
They are seeking for injunction not to alienate. They have filed a suit after 48 years based on the oral gift deed.
Tomorrow.
Please.
It's the matter tomorrow. Yes.
35 minutes. I am for the appellant, my lord. Any day, my lord, to the convent of
35 admission.
House.
Relist. Fresh matter, is it?
Fresh matter.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ directed notice ಆಗಿದೆ.
Notice ಆಗಿದೆ. Notice ಆಗಿದೆ.
That has to be heard, my lord.
Heard.
And criminal order records is necessary in this matter.
PCR to be summoned. This the matter in the second week of March.
Records ಇಲ್ಲೇ ಇದೆ.
Serial number 41, my lord.
ಇಲ್ಲೇ ಇದೆ.
State has filed the objection, my lord. The matter of urgency, my lord, the pensionary benefits, sir, they have not been equally paid to the petitioners herein.
Then 41.
41, my lord.
Huh? B group. It has to be heard, but we can't take it in the next week. Relist the matter in the second week of March.
But serial number 40, my lord.
Could I request first week, my lord, second week
First
again?
week of March. Yes.
Serial number 40, my lord. Adu B group matter. It's covered by the, my lords, two judgments of division bench of this honorable court. What has happened, my lords, in that case, wherein the Lokayukta disciplinary proceedings are initiated against this petitioner. In the entire, my lords, proceedings, what he did is, he receives an application, my lords. He writes it forward to the concerned department. This is the only thing I did, my lords. And the departmental deputy commissioner has reported that there is nothing misconduct has been happened. And this honorable court held that, my lords, in order to, my lords, frame the charge, there should be a sufficient material, at least prima facie material. And this honorable division bench of this honorable court has quashed some similar terms, my lords. Because I did nothing, my lords, only I written that it has forwarded to the concerned department. And complainant does not name my name, my lords. He names the revenue inspector who has least to be received.
Yes, you take a chance next week.
Other next week, one date quarter, it can be disposed. I produce the judgments also along with memo.
You're saying there is no lapse.
There is no lapse. Even that can't be taken as a, my lords, misconduct. When in a usual course, I writes it.
Serial number 37, any
30?
date, 37, date, your lordship.
Fresh matter, is it?
Service of summons has been, 2 times it has been hand delivered, your lordship.
Served, not represented.
To the council in the trial court, it has been served.
What has happened to court notice?
A court notice has been served, but not served. Second time, hand summons has been served to the sister-in-law of the respondent. And the third time, it has been served to the council to the trial.
Trial court, what is the order in the trial court? What is the judgment in the trial court?
Judicial separation of 3 years in divorce case. So for that, I have come for appeal.
So
They don't want to live together, your lordship. As respondent has also conveyed it to the council to the trial court.
they don't want to.
No.
Then try to see if we can settle it.
But he is not coming there also. NBW is issued in execution petition, your lordship, there in lower court.
Okay. Then we'll have it some date. Let us see. Huh?
Yes.
Relist the matter in the second week of March. Date good. Yes.
Serial number 45, my lord, state appeal, my lord, criminal appeal. Any date? Old one, my lord, 2016 matter.
I type note on. Oh, state appeal. It's only the sword. It has not fallen down. It's only hanging. Hang ಆಗ್ತಿದೆ ಅಲ್ವಾ? ನೋಡೋಣ. Relist the matter in the second week of March. Yes.
Serial number 22, my lord, passed over. Other, my lord.
We'll take up after criminal appeal.
Please wait.
Please.
In 15 minutes. Yes, Mr. Mastana.
Back at 4 o'clock.
ಅದು ಒಂದೇ ಒಂದು ಡಿಕ್ಟೇಷನ್ ಕೊನೆಯಲ್ಲಿ ನೋಡೋಣ.
Otherwise, your lordship, morning first hour itself, my lord. Additional Advocate General is also line, my lord. Uliyappa error case. First matter, your lordship, tomorrow only.
Lord, ready, my lord. I was asked to produce appointment orders. I am produced.
We have to only dictate. Some will dictate.
My lord's convenience. Tomorrow.
List the matter in the preliminary hearing list tomorrow.
Top of the list.
The preliminary hearing list tomorrow. Preliminary hearing list.
ಇಲ್ಲ ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಇದೆ, ಆರ್ಡರ್ಸ್ ನಲ್ಲೇ ಇರ್ಲಿ.
ಅದು preliminary hearing ಕಿಂತ ಮುಂಚೆ ಬರ್ತಿದ್ಯಾ?
ಇಲ್ಲ, ಇವತ್ತು ಆರ್ಡರ್ಸ್ ನಲ್ಲೇ ಇದೆ.
Same stage.
ಸೇಮ್ ಸ್ಟೇಜ್.
ಅದು ಒಂದು ಪೇಜ್ ಇದು ಒಂದು ಪೇಜ್ ಬರ್ಕೊಂಡ್ ಬನ್ನಿ, ಡಿಕ್ಟೇಟ್ ಮಾಡಕ್ ಸುಲಭ ಆಗುತ್ತೆ. ನೀವು ನಿಮ್ ನೋಟ್ನೇ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀವಿ.
ಗ್ರೇಟ್.
Please. My lord, this appellant present appeal. And they have been convicted in SC number 3 of 15. Convicting the appellant on 10/7/2017 pertaining to the.
Now there are 3 accused.
Please.
All the accused are convicted.
Convicted, my lord. Convicted for the offence punishable under section 302 is measure, my lord. Brief fact of the story is concerned, my lord. On 14/6/2014, my lord, at about 5:30 PM.
Just a minute. Before that, Suryaka, the accused number 2 is the son of accused number 1.
Yes, my lord.
Accused number 3 is the wife of
Wife of the accused.
all the entire family.
Yes, yes.
All are in custody.
Yes, no, my lord.
Then
Appellant number 1 and 3 already has been released on. By
A2 is in custody.
Only appellant number 2 is in custody since 10 years, 8 months, my lord. My lord, this matter is pertaining to SC number 3 of.
Come to read exhibit P1. Complaint ಓದಿಬಿಡಿ.
Please. ಹೀಗಿದ್ದು ನಮ್ಮ ಗ್ರಾಮದ ಹದ್ದಿನಲ್ಲಿ ನನ್ನ ಗಂಡನಾದ ದೇವೇಂದ್ರಪ್ಪ ಇತನ ಹೆಸರು ಜಸ್ಟ್ ಶಶಿಕಲಾ ವೈಫ್ ಆಫ್ ದ ಡಿಸೀಸ್ ಹ್ಯಾಸ್ ಬೀನ್ ಲಾಡ್ಜ್ ದ ಕಂಪ್ಲೇಂಟ್, ಮೈ ಲಾರ್ಡ್. ದೇವೇಂದ್ರಪ್ಪ ಡಿಸೀಸ್, ಮೈ ಲಾರ್ಡ್. ಹೆಸರಿಗೆ 10 ಗುಂಟೆ ಜಮೀನು ಇದ್ದು ನಮ್ಮ ಅಣ್ಣ ತಮ್ಮಕಿಯ ಸೂರ್ಯಕಾಂತ್, ದಟ್ ಈಸ್ ಅಪ್ಲೆಂಟ್ ನಂಬರ್ 1, ಸರ್.
ಅಣ್ಣ ತಮ್ಮಕಿ ಅಂದ್ರೆ ಬ್ರದರ್,
ಡಿಸ್ಟೆನ್ಸ್ ಬ್ರದರ್ಸ್, ರಿಯಲ್ ಬ್ರದರ್, ನಾಟ್ ರಿಯಲ್ ಬ್ರದರ್ಸ್, ಡಿಸ್ಟೆನ್ಸ್ ರಿಲೇಟಿವ್ಸ್. ಇವರ ಹೊಲವು ಸಹ ಸದರಿ ನಮ್ಮ ಹೊಲಕ್ಕೆ ಹತ್ತಿಕೊಂಡಿದ್ದು, ಈಗ ಕೆಲವು ದಿನಗಳ ಹಿಂದೆ ಸೂರ್ಯಕಾಂತ್ ತಂದೆ ಗುಂಡಪ್ಪ ಹಾಗೂ ಆತನ ಹೆಂಡತಿ ತಾರಾಬಾಯಿ, ಅಪೆಲೆಂಟ್ ನಂಬರ್ 3, ಮಕ್ಕಳಾದ ಗುಂಡಪ್ಪ, ದೇವಪ್ಪ ಈಸ್ ಜೇವೋ, ಮೈ ಲಾರ್ಡ್, juvenile offender, my lord. Child conflict with law, that is separate charge sheet has been filed and this matter is posted, sir. ಸದರಿ ಹೆಸರಿಗೆ ಇದ್ದ ಜಮೀನಲ್ಲಿ ತಮಗೂ ಸಹ ಪಾಲು ಬರುತ್ತದೆ ಅಂತ ಆಗಾಗ ನಮ್ಮ ಸಂಗಡ ತಂಟೆ ತಕರಾರು ಮಾಡುತ್ತಾ ಬಂದು, ಹೋದ ವರ್ಷ ಅದೇ ಹೊಲದ ಪಾಲಿನ ಸಂಬಂಧ ಜಗಳ ತೆಗೆದು ಒಬ್ಬರಿಗೊಬ್ಬರು ಹೊಡೆಬಡೆ ಮಾಡಿದ್ರಿಂದ ಒಬ್ಬರ ಮೇಲೆ ಒಬ್ಬರ ಕೇಸ್ ಸಹ ಆಗಿರುತ್ತದೆ. ಇಂದು ದಿನಾಂಕ 14/6/2014 ಸಾಯಂಕಾಲ 5:30 PM ನಾನು ನನ್ನ ಮನೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಾ ಕುಳಿತಿದ್ದಾಗ ನನ್ನ ಗಂಡ ದೇವೇಂದ್ರಪ್ಪ ಇತನು ನಮ್ಮ ಮನೆಯ ಮುಂದೆ ಇರುವ ಅಗಸಿಯ ಹತ್ತಿರ ಕುಳಿತು ತನ್ನ ಹೆಸರಿಗೆ ಇದ್ದ 10 ಗುಂಟೆ ಜಮೀನು ಯಾರಿಗಾದರೂ ಮಾರಾಟ ಮಾಡುತ್ತೇನೆ ಅಂತ ಮಾತನಾಡುತ್ತಾ ಕುಳಿತಿರುವಾಗ ಅದೇ ಸಮಯಕ್ಕೆ ಗುಂಡಪ್ಪ ಸೂರ್ಯಕಾಂತ್ ತಳವಾರ್, ತಾರಾಬಾಯಿ ಗಂಡ ಸೂರ್ಯಕಾಂತ್ ತಳವಾರ್, ದೇವಪ್ಪ ತಂದೆ ಸೂರ್ಯಕಾಂತ್ ತಳವಾರ್ ಇವರೆಲ್ಲರೂ ಕೂಡಿ ಕೈಯಲ್ಲಿ ಕೊಡಿಗೆ ಬಡಿಗೆ ಹಿಡಿದುಕೊಂಡು ಬಂದು ನಾಡುತ್ತಾ ಕುಳಿತ ನನ್ನ ಗಂಡನಿಗೆ ಹೇಗೆ ಮಾರಾಟ ಮಾಡುತ್ತಿ, ಅದರಲ್ಲಿ ನಮಗೆ ಪಾಲು ಬರುತ್ತದೆ, ಎಷ್ಟು ಸಾರಿ ಹೇಳಿದರೂ ಕೇಳುತ್ತಿಲ್ಲ, ಇಂದು ನಿನಗೆ ಜೀವ ಸಹಿತ ಬಿಡುವುದಿಲ್ಲ ಅಂತ ಬೈದು ಗುಂಡಪ್ಪ ಇತನು ತನ್ನ ಕೈಯಲ್ಲಿದ್ದ ಕೊಡಲಿಯಿಂದ ನನ್ನ ಗಂಡನ ತಲೆಯ ಹಿಂದೆ ಜೋರಾಗಿ ಹೊಡೆದು ಭಾರೀ ರಕ್ತಗಾಯ ಪಡಿಸಿದ ಪರಿಣಾಮ A2 ಅಪ್ಲೆಂಟ್ ನಂಬರ್ 2, ಮೈ ಲಾರ್ಡ್. ನನ್ನ ಗಂಡ ಸ್ಥಳದಲ್ಲಿಯೇ ಬೇಹೋಸಾಗಿ ಬಿದ್ದನು. ಆಗ ನಾನು ಹೀಗೆ ಏಕೆ ಹೊಡೆಯುತ್ತಿರುವಿರಿ ಅಂತ ನಡುವೆ ಜಗಳ ಬಿಡಿಸಲು ಹೋದಾಗ ಸೂರ್ಯಕಾಂತ್ ಇತನು ತನ್ನ ಕೈಯಲ್ಲಿದ್ದ ಬಡಿಗೆಯಿಂದ ನನ್ನ 2 ಕೈಗಳ ಹಸ್ತದ ಮೇಲ್ಗಡೆ ಹೊಡೆದು ಭಾರೀ ರಕ್ತಗಾಯ ಪಡಿಸಿದನು. A1, ಮೈ ಲಾರ್ಡ್. ಆಗ ತಾರಾಬಾಯಿ ಮತ್ತು ದೇವಪ್ಪ ಇಬ್ಬರು ಬಹಳ ಹೆಚ್ಚಾಗಿದೆ ಅಂತ ಬೈದು ಕೈಯಿಂದ ಮತ್ತು ಕಾಲಿನಿಂದ ನನಗೆ ಹೊಡೆಬಡೆ ಮಾಡುತ್ತಿದ್ದಾಗ ನಾನು ಚೀರಾಡಲು ಅಲ್ಲೇ ರಸ್ತೆಗೆ ನಿಂತಿದ್ದ ನಮ್ಮ ಗ್ರಾಮದ ಬಾಬು ತಂದೆ ತಮ್ಮಣ್ಣ ಹೆಬ್ಬಾಳ್ ಮತ್ತು ಕಾಮಣ್ಣ ತಂದೆ ರೇವಣ ಸಿದ್ದಪ್ಪ ಬೇನೂರ್ ಇವರು ನೋಡಿ ನಮಗೆ ಹೊಡೆಬಡೆ ಮಾಡುವುದನ್ನು ಬಿಡಿಸಿದರು. ನಂತರ ನಾನು PW 10 and 11, my lord.
PW 10 and 11.
10 and 11, my lord.
ಕಾಮಣ್ಣ 11.
Yes, my lord. ನಂತರ ನಾನು ಅಲ್ಲೇ ಹಾಜರಿದ್ದ ಕಾಮಣ್ಣ ಇಬ್ಬರು 108 ಆಂಬ್ಯುಲೆನ್ಸ್ ಬರಲು ತಿಳಿಸಿ ಅದು ಬಂದ ನಂತರ ಅದರಲ್ಲಿ ನನ್ನ ಗಂಡನಿಗೆ ಹಾಕಿಕೊಂಡು ಉಪಚಾರ ಕುರಿತು ಇಲ್ಲಿಗೆ ಬಂದು ಸೇರಿಕೆಯಾಗಿರುತ್ತೇವೆ. ದಟ್ ಈಸ್ ಯುನೈಟೆಡ್ ಹಾಸ್ಪಿಟಲ್, ಮೈ ಲಾರ್ಡ್. ಸದ್ಯ ನನ್ನ ಗಂಡ ಮಾತನಾಡುವ ಸ್ಥಿತಿಯಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಕಾರಣ ಮೇಲೆ ನಮೂದಿಸಿದ ಆರೋಪಿತರು ಹೊಲದ ಪಾಲಿನ ಸಂಬಂಧ ಜಗಳ ಮಾಡುತ್ತಾ ಬಂದು ಅದೇ ವೈಮನಸ್ಸಿನಿಂದ ನನ್ನ ಗಂಡನಿಗೆ ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಕೊಡ್ಲಿಯಿಂದ ತಲೆ ಹಿಂದೆ ಹೊಡೆದು ಭಾರಿ ರಕ್ತಗಾಯಪಡಿಸಿ ಬಿಡಿಸಲು ಹೋದ ನನಗೂ ಸಹ ಕಟ್ಟಿಗೆಯಿಂದ ಕೈಯಿಂದ ಕಾಲಿನಿಂದ ಹೊಡೆಬಡೆ ಮಾಡಿ ಭಾರಿ ರಕ್ತಗಾಯಪಡಿಸಿದ್ದು ಸದರಿಯವರ ವಿರುದ್ಧ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಬೇಕಂತ ವಿನಂತಿ.
So 14/6, 9 p.m.
Yes, my lord.
On that day only, in the night hours, she lodged a complaint.
Yes, my lord.
So 307 ಗೆ ಆಯ್ತಾ registered FIR?
First FIR 307.
307.
And very next day, that is 15/6/2014.
She succumbed.
Succumbed death. Very next day, my lord.
So
On the way to government hospital, when he was referred to higher treatment during the course, he succumbed.
So 302 invoked.
Invoked, my lord.
Yes.
Accordingly, investigation has completed and charge sheet is filed under section 302, 323, 504, 506, my lord. And they found guilty for the offense, same, my lord.
Yes.
And my case is that, my lord, the prosecution have duly examined PW1 to PW22. Wherein, my lord, they have not supported, some of the witnesses not supported.
What about these three eyewitness? Now, according to complaint, PW1 is the injured eyewitness.
Yes, my lord.
Wife of deceased.
Yes, my lord.
PW10, PW10,
10 and 11. my lord.
PW10 and 11, both of them were supported, Thammanna and Kamanna.
How supported? Supported, my lord.
Yes. Just our three PW1, 10, 11, the evidence was the sir.
Suresh Babu, my lord. Suresh Babu, PW10.
Yes.
My lord, complainant has given the complaint, my lord, but her cross-examination at page number 63, my lord. Page number 63, last paragraph, my lord. United ಆಸ್ಪತ್ರೆಗೆ ಪೊಲೀಸರು ಬಂದಿರಲಿಲ್ಲ. Lower fourth line, my lord. ಯುನೈಟೆಡ್ ಆಸ್ಪತ್ರೆಗೆ ಪೊಲೀಸರು ಬಂದಿರಲಿಲ್ಲ. ಪೊಲೀಸರಿಗೆ ನಾನು ಫಿರ್ಯಾದಿಯನ್ನು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ ಮತ್ತು ಘಟನೆ ಬಗ್ಗೆ ಹೀಗೆ ಆಗಿದೆ ಅಂತ ಪೊಲೀಸರಿಗೆ ಹೇಳಿ ಬರೆಸಿಲ್ಲ ಅಂದರೆ ಸರಿ. ಫಿರ್ಯಾದಿಯಲ್ಲಿ ಏನು ಬರೆದಿದ್ದಾರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆ ಸಮಯದಲ್ಲಿ ನನಗೆ ಅರಿವು ಇರಲಿಲ್ಲ. ಅದನ್ನು ಯಾರು ಬರೆಸಿದ್ದಾರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. Overall, she has not supported. And
ಕೂಲಿ ಏನ್ ಗೊತ್ತಿರುತ್ತೆ?
even she does not know the contents of the fact also, my lord. Under due influence of some relatives, she has made the
illiterate. ಎಲ್ಲಿ ಗೊತ್ತಿರುತ್ತೆ? ಕೂಲಿ ಅಲ್ವಾ? That is one aspect.
Yes, my lord. But however, my lord, one of the case has been registered against accused number 4, that is CCL, my lord. That number has numbered as JC number 63 of 14, my lord, against JJ board.
Now, tell us one thing. What is the injury sustained by this PW1?
PW1 sustained simple injuries, but she has
ಇದೆ wound certificate ಎಲ್ಲಿದೆ? ಯಾರು ಡಾಕ್ಟರ್ ಟ್ರೀಟ್ ಮಾಡಿದ್ದು? Who is the doctor treated her? PW?
primarily she has refused to take the treatment, my lord.
ಯಾರು ಡಾಕ್ಟರ್ ಯಾರು? PW.
PW
18 PW 18
Oh, sir. PW 18. Doctor.
18
PW 18, sir. Dr. Shashindra Deshmukh. Sudhindra Deshmukh, my lord. At page number 130, my lord.
130. Initially, he treated this Devappa also.
Devappa also he is treated.
Treated also.
Yes, my lord. And meanwhile, he has given
I
treatment.
examined, ಕೆಳಗಡೆ ಓದಿ, I examined CW1 Shashikala.
Yes,
and found swelling, tenderness, movement restriction on right hand.
Yes, my lord.
For that
Patient refused to investigation.
What is the wound certificate?
But,
Exhibit P12
Exhibit P12. my lord.
ಏನಿದೆ P12 ಅಲ್ಲಿ? Previous injury or simple injury?
Simple injuries.
ಎಲ್ಲಿದೆ? P12 ಓದಿ. Page 39.
Movement restriction on right hand, my lord.
Swelling,
and opinion
tenderness,
cannot.
movement restriction.
Yes, cannot be given unto opinion.
Patient refused for investigation. So opinion not given.
Yes. Yes.
Opinion ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ.
So simple injuries ಅದು.
How sir? Movement restricted ಅಷ್ಟೇ.
So PW1 evidence that who assaulted to deceased?
Appellant assaulted by means of axe on the head.
So PW1 prakara, as per PW1, who assaulted her husband?
Appellant number 2 assaulted by means of axe on the head of the deceased man, thereby causing grievous injury.
How many wounds, injuries are there?
As per the postmortem, my lord, only one injury backside of the head of the deceased, my lord.
From where you got the axe that this one?
My lord.
Weapon
record, my lord.
From where you got the weapon at the time of incident? ನೀವು ಇಟ್ಕೊಂಡು ಹೋಗಿದ್ದೀರಾ ಅಲ್ಲ ಎಲ್ಲಿಂದ ಬಂತದು?
Thereafter ಅದು ರಿಕವರಿ ಆಗಿದೆ ಸರ್.
ಇನ್ಸಿಡೆಂಟ್ ಗೆ ನೀವು ಅಲ್ಲಿ ತಗೊಂಡು ಹೋಗಿದ್ದೀರಾ?
Holding with allegation, as per the allegation, they holding the weapons.
Holding the weapons. Your house also situated ಅಲ್ಲೇ nearby?
Adjacent
house.
Very next house is that.
Read that portion of evidence of PW1. PW1 ಏನ್ ಹೇಳ್ತಾರೆ ಚೀಫ್ ಅಲ್ಲಿ ಹೇಳಿ ನೋಡಿ.
My lord, at page number 58. my lord. ಸುಮಾರು 1 ವರ್ಷದ ಹಿಂದೆ ಸಾಯಂಕಾಲ 5:30 ಗಂಟೆಗೆ ನಾನು ಮನೆಯಲ್ಲಿ ಅಡಿಗೆ ಮಾಡುತ್ತಿದ್ದಾಗ ನಮ್ಮ ಮನೆಯವರು ದ್ಯಾವಮ್ಮ ದೇವರ ಕಟ್ಟೆ ಹತ್ತಿರ ಕುಳಿತಿದ್ದರು. ಅವರೆಲ್ಲರೂ ಆರೋಪಿತರೆಲ್ಲರೂ ಸೇರಿ ಬಂದು ನನ್ನ ಗಂಡನಿಗೆ ರಂಡಿ ಮಗನೇ ಹೊಲ ಕೊಡುವುದಿಲ್ಲ ಎಂದು ಹೇಳುತ್ತಾ ಗುಂಡಪ್ಪ ಕೈಯಲ್ಲಿ ಕೊಡ್ಲಿ ಮತ್ತು ಸೂರ್ಯಕಾಂತ್ ಕೈಯಲ್ಲಿ ಬಡಿಗೆ ಇತ್ತು. ಆರೋಪಿ ಗುಂಡಪ್ಪ ತನ್ನ ಕೈಯಲ್ಲಿದ್ದ ಕೊಡಲಿಯನ್ನು ತೆಗೆದುಕೊಂಡು ನನ್ನ ಗಂಡನ ತಲೆಗೆ ಹಿಂಬದಿಗೆ ಹೊಡೆದಿರುತ್ತಾನೆ. ಕೊಡಲಿಯಿಂದ ಹೊಡೆದ ನಂತರ ರಕ್ತಗಾಯವಾಗಿರುತ್ತದೆ. ಆ ಸಮಯದಲ್ಲಿ ನಾನು ಬಂದು ನನ್ನ ಗಂಡನಿಗೆ ಹೊಡೆಯಬೇಡ್ರಿ ಅಂತ ಹೇಳಿದಾಗ ತಾರಾಬಾಯಿ ಸೂರ್ಯಕಾಂತನು ಬಡಿಗೆಯಿಂದ ನನ್ನ 2 ಕೈಗಳಿಗೆ ಹೊಡೆದಿರುತ್ತಾನೆ. ದೇವಪ್ಪ ಕಾಲಿನಿಂದ ಒದ್ದಿರುತ್ತಾನೆ. ಕಾಮಣ್ಣ ಮತ್ತು ಬಾಬು ಎಂಬುವರು ಜಗಳ ನೋಡಿ ಬಿಡಿಸಿರುತ್ತಾರೆ. ನಂತರ ಆಂಬ್ಯುಲೆನ್ಸ್ಗೆ ಫೋನ್ ಮಾಡಿ ನನ್ನ ಗಂಡನಿಗೆ ಆಂಬ್ಯುಲೆನ್ಸ್ ನಲ್ಲಿ ಹಾಕಿಕೊಂಡು ಕೋರ್ಟ್ ಹತ್ರ ಇರುವ ಆಸ್ಪತ್ರೆಗೆ ತಂದು ಹಾಕಿರುತ್ತೇವೆ. ಸದರಿ ಜಗಳವು ಹೊಲದ ಸಂಬಂಧ ಆಗಿರುತ್ತದೆ. ನಂತರ ಅವರು ಹೆಚ್ಚಿನ ಚಿಕಿತ್ಸೆ ಕುರಿತು ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಒಯ್ಯುತ್ತಿರುವಾಗ ದಾರಿಯಲ್ಲಿ ಮೃತಪಟ್ಟಿರುತ್ತಾರೆ. ನಾನು ನೀಡಿದ ಫಿರ್ಯಾದಿಯಲ್ಲಿ ನೋಡಿರುತ್ತೇನೆ. ಆ ನೀಪಿ 1 ಅಂತ ಗುರುತಿಸಲಾಯಿತು. ಅದರ ಮೇಲಿರುವ ಹೆಬ್ಬೆಟ್ಟಿನ ಗುರುತು ನನ್ನದೇ ಆಗಿರುತ್ತದೆ.
ಅಲ್ಲೇನಾದ್ರೂ ಗಲಾಟೆ ಆಯ್ತಾ? ಹೇಗೆ ಮಾರಾಟ ಮಾಡುತ್ತೀರಿ ಅಂತ ಗಲಾಟೆ ಆಯ್ತಾ?
ಗಲಾಟೆ ಆಗಿಲ್ಲ ಸರ್. ಗಲಾಟೆ ಆಗಿಲ್ಲ ಸರ್. ಬಂದ್ರು ಹೊಡೆದ್ರು ಅಂತಿದೆ, ಏನು ಗಲಾಟೆ ಇಲ್ಲ.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನಿದೆ? ಎಕ್ಸಿಬಿಟ್ P1 ಇವರೆಲ್ಲರೂ
ಎಕ್ಸಿಬಿಟ್ P1 ಪ್ರಕಾರ ಅವ್ರ ಆಸ್ತಿ ಹತ್ರ ಜಗಳ ಇತ್ತು. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಇವರೆಲ್ಲ ಅಲ್ಲಿಗೆ ಬಂದ್ರು ಅಂತ ಅಷ್ಟೇ.
ಸೊ PW1011 ಏನ್ ಹೇಳ್ತಾರೆ? ವಾಟ್ ಅಬೌಟ್ PW10 and 11?
PW10
PW10 ಬನ್ನಿ.
ಹೌದು ಸರ್. PW PW10, but in his cross examination, my lord, he has not given any statement to the police antidan. At page number 100, accordingly he was eyewitness to the incident, my lord, but he stated before the trial court.
Statement recorded PW10.
PW very next day statement has been recorded on 15th.
PW8 also eyewitness to the incident.
Later further statement has been recorded.
PW8 kuda.
How sir?
Santosh.
Later ಅವ್ರ ಹೆಸರು ಆನಂತರ ಬಂದಿದೆ ಸರ್. ಅದು
ಅವರು eyewitness is also eyewitness to the incident.
Frequently he came at the time of incident. He saw the incident from some distance ಅಂತಿದೆ.
PW11 shifted to the
along with complainant, he shifted to the hospital.
What is his evidence?
He supported, my lord. He supported, but he turned hostile in another case, my lord. Before the JJ board, he turned hostile.
Whether these accused number 2 and 3 assaulted to the deceased?
No, no, sir. Did not touch the body, sir. Did not, as per the say of the complainant, they did not touch that.
They 2 also not assaulted to this PW1?
Yes, ma'am. Yes, ma'am.
PW1?
No, no, no. Only allegation is he assaulted only deceased only. Appellant 1 and 3 assaulted to complainant PW1 only.
They sustained simple injuries.
Yes.
She sustained simple injury.
Yes. And
now what is your argument?
Sir, there is no case made out by the prosecution, my lord. Number of inconsistencies and contradictions available. And as far as the say of the complainant PW1 does not accept it, because she stated that she is not under the proper condition to give the statement, and somebody has given the statement recorded.
So according to you, conviction is?
Sir, all our relatives is together. The village Uni is having number of communities, houses nearby the house, place of incident. But I put some questions.
Why we should disbelieve the evidence of all these eyewitnesses? PW1, 8, 10, 11, 15.
Sir, they are all not supported in SC case, sir. In JC, one of the accused CCL, wherein they are not supported single, much less they could not give a single material. I have submitted for kind perusal of all those statements.
They have not participated. ಯಾರೆಲ್ಲ ಹೊಡೆದಿದ್ದಾರೆ ಅವ್ರ ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ. Why we should disbelieve the evidence on record?
But my submission is that, my lord, Suresh, Davanna, Nagaraj, Rajshekar, Sharanbasappa, Santosh, all are relatives to the deceased persons. All are relatives. Except the relative, there is no any material witness uh, collected by the investigation officer. They too not supported. Partly they have supported, my lord.
PW 10 and 11 are the neighbors. They are not relatives.
Our relatives.
Uh,
Our close relatives.
relatives ಅಂತ ಹೇಳಲ್ಲ.
It is on the record, my lord. When I put the question before that learned sessions court, at that time they admits.
ನೀವೇ ಕಂಡಕ್ಟ್ ಮಾಡಿದ್ದ?
ನಾನೇ ಕಂಡಕ್ಟ್ ಮಾಡಿದ್ದೆ. ಅವಾಗ್ಲೂ ಹೇಳಿದಾರೆ ಎಲ್ಲ ನಾವು ರಿಲೇಟಿವ್ಸ್ ಇದ್ದೀವಿ ಅಂತ ಹೇಳಿ. ಈವನ್ ರಿಕವರಿ ಮಾಡೋದ್ರಲ್ಲಿ ವೆಪನ್ ರಿಕವರಿಗೂ ಇಬ್ಬರು ವಿಟ್ನೆಸ್ ತಗೊಂಡೋಗಿ ಅವರು ಕೂಡ ರಿಲೇಟಿವ್ಸ್ ಪೊಲೀಸ್ನವ್ರು ಜೀಪ್ ನಲ್ಲಿ ತಗೊಂಡೋದ್ರು, ಇವರೆಲ್ಲ ಅಲ್ಲಿ ಅಂತಂದ್ರು, ಮತ್ತೆ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಸೈನ್ ಮಾಡಿದೀವಿ.
So the entire judgment has to go according to you.
Yes,
it's liable to be set aside.
Yes. Now appellant number 1 Suryakant, my lord, who died on 27/1/2024, my lord.
Appellant number 1.
1, my lord.
Already died, huh?
Yes, my lord. Recently in the month of January 2024, my lord.
Against him abates. So appeal against him abates.
Yes.
Now what about 2 and 3?
3, my lord. 3 is a woman folk, my lord. She is not at all involved in such offense, my lord. Only allegation is she has slapped on the complainant.
ಏನು offense ಬರುತ್ತೆ ಅದಕ್ಕೆ? ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ ನೀವು? ಅಲ್ಲಿನೂ ಇದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೀರಿ? ಕಂಪ್ಲೀಟ್ ಎಕ್ವಿಟಲ್ ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೀರಿ? ಬೇರೆ ಏನಾದರೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೀರಿ? ಆಲ್ಟರ್ನೇಟಿವ್ ಕಂಟೆನ್ಷನ್ ಏನಾದರೂ ತಗೊಂಡಿದ್ದೀರಿ? Have you raised any alternative contention before the trial court?
Prosecution have not fully established the case ಅಂತ ಹೇಳಿ ಮಾಡಿದೀವಿ, my lord.
34 ಬಗ್ಗೆ ಏನು ಹೇಳ್ತೀರಾ?
ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಅಂತ
34 ಬಗ್ಗೆ ಏನು ಹೇಳ್ತೀರಾ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿ
ಅದರ್ ಕಂಪ್ಲೇನೆಂಟ್ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಅವ್ರ ಕಂಪ್ಲೇನೆಂಟ್ ಹೇಳ್ತಾರೆ ನನಗೆ ಹೊಲ ಗೊತ್ತಿಲ್ಲ, ಇವ್ರು ಯಾರಿಗೂ ಹೊಲ ಇಲ್ಲ ಊರಲ್ಲಿ, ಆ ಹೊಲದ ಬಗ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಡಿಸ್ಪ್ಯೂಟೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿ. 10 ಗುಂಟಾಸ್ ಆಫ್ ಲ್ಯಾಂಡ್ಗೋಸ್ಕರ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್. ಆ ನಂತರ ನನಗೆ ಹೊಲನೂ ಗೊತ್ತಿಲ್ಲ, ನಾನು ನೋಡೂ ಇಲ್ಲ, ಆ ಹೊಲ ಎಲ್ಲಿದೆ ಗೊತ್ತಿಲ್ಲ.
So since they are relative witness, their evidence cannot be considered. That is your argument.
Please.
ಮತ್ತೆ ಕಾಂಟ್ರಡಿಕ್ಷನ್ಸ್ ಇದೆ.
ಕಾಂಟ್ರಡಿಕ್ಷನ್ಸ್ ಅಂತೂ ನಂಬರ್ ಆಫ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್. ಈಗ ಅವರು ಕಂಪ್ಲೇನೆಂಟ್ ಹೇಳ್ತಾರೆ ಸರ್ ಅಟ್ ಪೇಜ್ ನಂಬರ್ 62 ಸರ್.
ಏನ್ ಹೇಳ್ತೀರಿ? ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಏನಿದೆ ಅದ್ರ ಬಗ್ಗೆ ನೋಡಿದ್ದೀರಿ? ನೋಡಿಲ್ಲ. $34 ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ ಕೇಳು ಸಾಹೇಬ್ರು. 34 ಬಗ್ಗೆ
ಕಾಮನ್ ಅಬ್ಜೆಕ್ಟ್, ಬಟ್ ಅವರು ಯಾರು ಕಾಮನ್ ಇಂಟೆನ್ಷನ್ ಏನು ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಅಂತ ಡಿಫೆನ್ಸ್ ತಗೊಂಡ್ವಿ. ಬಟ್ ದೇ ಆರ್ ಹ್ಯಾಚಿಂಗ್ ದ ಸ್ಟೋರಿ ಸರ್, ಎಲ್ಲರೂ ಯೂಸ್ ಮಾಡಿ. ಆಮೇಲೆ ನನಗೆ ಹೊಡೆದಿಲ್ಲ ಅಂತ ಅಮ್ಮ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸರ್. ಜೆ ಬೋರ್ಡ್ ನಲ್ಲಿ ಬೇರೆ ಡಬಲ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದರಲ್ಲಿ ಸಪೋರ್ಟ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಏನೋ ರಿಕವರಿ ನೋಡಿಲ್ಲ, ಘಟನೆ ನೋಡಿಲ್ಲ, ಯಾರು ಸಪೋರ್ಟ್, ಈವನ್ PW10 PW11 ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ.
A2 ಆಕ್ಟ್ ಮತ್ತು 123 ಆಕ್ಟ್ ಅನ್ನು ನೀವು ಬೈಫರ್ಕೇಟ್ ಮಾಡಬೇಕು. ಫಸ್ಟ್ ಇನ್ಸ್ಟೆನ್ಸ್ A1 ಏನ್ ಮಾಡಿದ, A1 and A3 ಏನ್ ಮಾಡಿದ್ರು, A2 ಏನ್ ಮಾಡಿದ್ರು ಅಂತ ಬೈಫರ್ಕೇಟ್ ಮಾಡಬೇಕು ಆಕ್ಟ್. ಸೊ 34 ಬರಲ್ಲ ಯಾರಿಗೆ?
A1 and A3
A3ಗೆ ಬರಲ್ಲ ಅಂತ. ಆಯ್ತಾ? ಬರಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರ ಆಕ್ಟ್ ಎಲ್ಲಿಗೆ ಬರುತ್ತೆ, ಯಾವ ಒಫೆನ್ಸ್ಗೆ ಬರುತ್ತೆ?
323, 324 ಅದು ಸರ್.
ಸಿಂಪಲ್ ಇಂಜುರಿ ಏನ್ ಬರುತ್ತೆ, ಇಲ್ಲಿಗೆ ಬರುತ್ತೆ
323, 324.
323 or 324. ಮತ್ತೆ ಇವೊಂದು ಏನ್ ಮಾಡ್ತೀರಿ A2 ಏನ್ ಬರುತ್ತೆ?
Might have assaulted with an axe, my lord. But that has been not proved by the prosecution before the learned sessions.
She has given evidence, no? She has given evidence. Recovery ಇದೆ.
Axe ಕೂಡ ಎಲ್ಲಿಂದ ಬಂತು ಅಂತ ಹೇಳಿ ಅವ್ರು ಹೇಳಿಲ್ಲ ಸರ್.
ಎಲ್ಲಿಂದ ಬರುತ್ತೆ? ನೀವೇ ತಗೊಂಡು ಹೋಗಿದ್ದೀರಿ. ರಿಕವರಿ ಆಲ್ಸೋ ಪ್ರೂವ್.
ರಿಕವರಿ ಇದೆ ಸರ್.
ರಿಕವರಿ ಪ್ರೂವ್ ಆಗಿದೆ. 5 and 6 PW 5 and 6.
ಹೌದು ಸರ್. ಅವ್ರು ಹೇಳ್ತಾರೆ ಸರ್, ಅವರು ಪೊಲೀಸರು ಕರೆದ್ರು ಹೋಗಿದೀವಿ, ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಸೈನ್ ಮಾಡಿದೀವಿ.
ಇವ್ರು ತೋರಿಸಿದ್ರು ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ಸಾಕಾಗುತ್ತೆ.
ಅವ್ರು ಕೂಡ ರಿಲೇಟಿವ್ಸ್ ಡಿಸೀಸ್.
ಆಯ್ತು, ಅವ ಬಂದು ಸಡನ್ ಹೊಡೆದ್ರೆ ಏನಾಗುತ್ತೆ
ಸರ್?
ಅವ ಬಂದು ಸಡನ್ ಆಗಿ ಹೊಡೆದ್ರೆ ತಲೆಗೆ ಒಂದು ಏಟಿ ಏನ್ ಮಾಡ್ಬೋದು?
ರೆಸ್ಕ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಪಡಬೇಕು.
No, we're saying in terms of sentence. In terms of sentencing, can you push him somewhere else? Can you go to some other section?
Part 2 ನಲ್ಲಿ ಬರ್ಸ. ಅಂಡರ್ ಸಡನ್ ಪ್ರೊವೊಕೇಶನ್ ಅಲ್ಲಿ
ಯಾವುದು ಪಾರ್ಟ್ 2?
304 part 2 ಸರ್.
ಹೇಗೆ ಬರುತ್ತೆ 304 part 2 ಹೇಗೆ ಬರುತ್ತೆ?
Sudden provocation, under sudden provocational incident take place.
Without premeditation, that much we can say. Not repeated abuse. ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಲ್ಲ, ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದನ್ನು
ಮಾಡಿದ್ವಿ.
ಈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಿ ಏನಾದ್ರು? ಮಾಡಿಲ್ಲ.
ಈ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ ಸರ್. 304 part 2
ಮಾಡ್ಬೇಕಲ್ವಾ ನೀವು? ಸೆಷನ್ ಟ್ರಯಲ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ, ಸೆಷನ್ ಟ್ರಯಲ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
2017 ನಲ್ಲಿ ಮ್ಯಾಟರ್ ಇಸ್ ಓಲ್ಡ್.
ನೀವು ಎಷ್ಟು ವರ್ಷದಿಂದ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ಸೆಷನ್ ಟ್ರಯಲ್?
25 years.
25 years ಅಲ್ಲಿ
ಮೊದಲು ಅವಾಗ ಜೂನಿಯರ್ ಇದ್ದಾಗ ಮಾಡಿದ್ದೀನಿ ಸರ್. 2017 ಮ್ಯಾಟರ್.
ವಿತ್ ಪರ್ಮಿಷನ್ ಸರ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ part 1
ಮಾಡಲ್ಲ ಸರ್.
only acquittal or conviction. Trial judge ಕನ್ಸಿಡರ್ ಮಾಡಲ್ಲ ಸರ್.
ಇಲ್ಲಿ ಸಚ್ ಬಾರ್ ಇದೆ, ಎಲ್ಲಿದೆ?
ಇದೆ ಸರ್, ಬಟ್ ಅದ್ರ ಕನ್ಸಿಡರ್ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿ ಅಕ್ವಿಟಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ ಸರ್. ದೇ ವಿಲ್ ಕಮ್. ಇಲ್ಲಿ ಏನಾದ್ರು part 1 part
2. So there was a civil dispute. Civil dispute ಇತ್ತು. ಸಡನ್ ಆಗಿ ಅಲ್ಲಿ ಬಂದು ಹೊಡೆದಿದ್ದಾನೆ A2. ಒಂದೇ ಏಟು ಹೊಡೆದದ್ದು, ಸಿಂಗಲ್ ಬ್ಲೋ, ರಿಪೀಟ್ ಮಾಡಿಲ್ಲ.
ಇಂಟೆನ್ಷನ್ ಇರಲಿಲ್ಲ,
ಇಂಟೆನ್ಷನ್ ಇಲ್ಲ, ಪ್ರಿಮೆಡಿಟೇಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ 304 part 1 ಗೆ ಕನ್ವಿಕ್ಷನ್ ಮಾಡಬೇಕು. ಎಕ್ಸೆಪ್ಷನ್ ಅಲ್ಲಿ ಬರುತ್ತೆ.
ದಯವಿಟ್ಟು ಮಾಡಿ
ಹಾಗೆ ಮಾಡ್ಬೇಕು ಆರ್ಗ್ಯುಮೆಂಟ್ ನೀವು. 1 and 3 ಇದು 302 ಗೆ ಬರಲ್ಲ, 323 or 324 ಬರುತ್ತೆ ಅಂತ ಮಾಡ್ಬೇಕು.
ಅದೇ ಕಾಂಟೆಂಟ್.
ಎಷ್ಟು ಸಮಯ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ರು ಅವರು? 1 and 3?
ಪ್ಲೀಸ್ ಸರ್.
1 and 3. How long they were in custody?
324 ನಲ್ಲಿ ಆಗಿದೆ.
ಎಷ್ಟು ಸಮಯ ಇದ್ರು ಕಸ್ಟಡಿಯಲ್ಲಿ? 1 and
45 ದಿವಸ ಇದ್ರು ಸರ್. 45 ದಿವಸ ಇರುತ್ತೆ.
45 ದಿವಸ. 45 days.
ಹೌದು ಸರ್. ಅಪ್ಲೈಂಟ್ ನಂಬರ್ 1 45 days ಸರ್. 23 days ಅವರು ಅಪ್ಲೈಂಟ್ ನಂಬರ್ 3 ಲೇಡೀಸ್.
ಎಷ್ಟಿದ್ರು?
23.
23 days.
ಡೇಸ್ ಸರ್. ಅಪ್ಲೈಂಟ್ ನಂಬರ್ 3 ಮಲೋಡ್.
ಫೈನ್ ಕಟ್ಟಬೇಕು.
ಪ್ಲೀಸ್.
ಫೈನ್ ಕಟ್ಟಬೇಕು ಇಬ್ರು.
ಪ್ಲೀಸ್.
ಅವ ಎಷ್ಟು ಕಟ್ತಾನೆ?
ಅಪ್ಲೈಂಟ್ ನಂಬರ್ 1 ಅಂತೂ
ಕಟ್ತಾನೆ.
appellant number 1 died. He is no more. Appellant number 1 is no.
ಅವ A2.
A2 ಇದೆ ಸರ್.
ಫೈನ್ ಕಟ್ತಾನಾ?
ಕಟ್ತೀವಿ.
ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
ಮಿನಿಮಮ್ ಫೈನ್. ಅವ್ರು ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ ಇದ್ದಾರೆ, ಅಗ್ರಿಕಲ್ಚರಲ್ ಲೇಬರ್ ಇದ್ದಾರೆ. Just 32 years old enough. At the time of commission of this offense, sir, he was 22-23 years old.
ಈಗ 10 ವರ್ಷ ಒಳಗಿದ್ದಾನಾ?
ಇದಾನ್ ಸರ್ ಒಳಗೆ.
Dictating judgment. Monday. Third the learned counsel for the appellant for the arguments of learned SPP. Monday.
ಮೆಮೊ ಹಾಕಿ
ಕೊಡ್ತೀನಿ.
Number 22.
Hello. Appear for appellant. This appeal is directed against allowing of MC petition filed by the respondent husband herein seeking dissolution of marriage on the ground of mental cruelty and desertion under section 13A, 13(1) and 13(1)A of Hindu Marriage Act. My lord, as I was saying before making submissions on the main, my lord, the order under challenge is, my lord, is liable to be set aside on the ground that, my lord, one is there is no original court has failed did not appreciate the evidence on record in a proper perspective. And my lord, my submission is on, my lord, on 3 to 4 folds. That is, one, husband, my lord, without making any efforts such as filing petition under section 9, he, my lord, directly filed a petition seeking dissolution of marriage. One aspect. And another aspect.
Even that, where is it that without filing restitution?
Yes, yes. Why I am saying so is because of this reason, my lord. It becomes vague and, my lord, baseless assertion at the hands of. please.
That we see in the
Yes, yes.
evidence.
I'll just, my lord, bring out, my lord, the line of my arguments. That's all. And, my lord, second one is, my lord, there are no independent witnesses examined on behalf of the respondent husband. Those circumstances exist and warrants to do so, my lord. And, my lord, third point, my lord, as held by Supreme Court to constitute and, my lord, mental cruelty, conduct of the party must be, my lord, so grave and vague, and it is not, my lord, usual wear and tear and wear of matrimonial life. And, my lord, it is equally well settled law that a person who files petition seeking dissolution of marriage, that is petitioner, party petitioner, it is burden is on him to establish the ground of, my lord, cruelty and desertion in terms of section 101 of, my lord, Evidence Act. It cannot shift on the, my lord, respondent wife. And there is evidence, my lord, during the course of cross examination, PW1 who is examined as husband, who is examined as PW1, categorically admits the fact that, my lord, while she was carrying, she was treated at Gangavati. She was given medical treatment. And, my lord, one more aspect of the matter is, my lord, all along in the petition, he asserts that, my lord, she was giving threatenings to commit suicide. Absolutely, it is not proved by placing materials. And circumstances, my lord, looking into the pleadings of the parties, absolutely, there is no, my lord, there is no situation for her to state, to threaten, my lord, the husband that she is going to commit suicide.
Much of the evidence is only within the four walls.
Please.
Yes.
Yes, my lord, may I now take lordships to the petition.
Let us look at the
file narrating. Yes, my lord.
Let us look at the reasoning.
Reasoning, my lord, reasoning
let us
appears
see,
to be, my lord, so simple, so casual.
No, that's why from para 11, we'll have a look at how
Please,
the
ma'am.
trial court has gone about the appreciation of evidence.
Please, ma'am.
From para 10, you read.
Yes.
Page 24.
Para 10, my lord, points for consideration.
Yes.
Whether the petitioner proves that respondent has treated cruelty to the petitioner. Whether petitioner proves that the respondent has deserted the petitioner for a continuous period of not less than 2 years, immediately preceding the presentation of the petition without reasonable cause. Whether petitioner is entitled for dissolution of marriage by decree of divorce. What order or decree? My lord, all that trial court places reliance, therefore, may I request relevant issue, para 18 onwards, my lord, documents produced by the.
Just read up the, now it's essentially one of interpretation of
Yes.
readings and evidence.
Yes.
So you just read from
Please.
para 11.
Para 10 onwards.
To give one complete
Great.
picture.
Great. Point para 12, my lord.
Yes.
Point number 1 and 2.
Yes.
Both points are interconnected with each other. In order to avoid repetition of the facts, both points are taken together for common discussion. The petitioner has filed the present petition seeking divorce on the ground of desertion and cruelty. Following facts are admitted by the petitioner and respondent. performance of marriage between the petitioner and respondent dated 19/4/2018 at Arshita Garden, Raichur is not in dispute. Both of their birth of their son, namely Vihan, is not in dispute. At this stage, it is useful to refer a decision reported in so and so. In this decision, Honorable Apex Court held as under burden must lie on the petitioner to establish his or her case. Ordinarily, the burden lies on the party which affirms a fact, not on the party which denies it. The burden lies on the petitioner to prove that respondent has treated cruelty to the petitioner. In the light of principles laid down in the above referred decision, the petitioner who files petition seeking divorce on the ground of cruelty, he must prove that respondent has treated him with cruelty. As such, burden is on the petitioner to prove that respondent has treated cruelty to him. In the written arguments, learned counsel for the petitioner has reiterated the petition arguments and further contended that after filing of present petition, the respondent has filed criminal cases before Gangavati police station in crime number so and so for offense punishable under section so and so. It also argued that the respondent has filed complaint before Human Rights Commission at Bangalore. It is also stated that the brother of respondent and his henchman attacked the petitioner at Gangavati. As such, the petitioner has filed a criminal case against the brother of respondent in crime number so and so of Gangavati police. It is also stated that respondent and her family members have illegally trespassed in the house of petitioner at Sirwar and quarreled with him, his mother and sister. As such, he lodged a complaint before Sirwar police station in crime number so and so. It is also argued that respondent and her family members have filed a criminal case before the Sirwar PS against the petitioner and his mother in crime number so and so. It is also argued that respondent and her family members have filed false criminal cases before the women's police station at Raichur in crime number 139 of 22 dated 22/9/2022 for the offense punishable under section 448 read with 34 of IPC. It is also argued that respondent has filed false criminal case against mother of petitioner and their agricultural coolie workers before the Sirwar PS in crime number so and so for offense so and so IPC dated 5/7/2023. Further, in the written arguments, the learned counsel for the petitioner mentioned several suggestions passed by the learned counsel for the several suggestions posed by the learned counsel for the respondent to PW1 to 3, PW1 to PW3, and the answer given by them during the course of their cross-examination. In support of their arguments, learned counsel for the petitioner cited following decisions.
Go to para 18.
Please. Para 18.
Read from para 18.
Para 18 also, it all with regard to, yes, please. Great. Now I discuss, yes. Now I discuss the documentary evidence produced by the petitioner. Exhibit P1 is a marriage invitation card of the petitioner and the respondent. Exhibit P2 is a certified copy of FIR in crime number so and so, and it suggests that petitioner has filed said criminal complaint before Gangavati police station, alleging that one Mukesh, the brother of respondent, and another two persons have committed the offense punishable under section 341, 504, 323, and 506 read with 34 of IPC. Exhibit P3 is a copy of police notice dated 7/1/2022, and it is show that Raichur Rural Police CPI has issued the said notice to the petitioner and his mother, directing them to appear before him for inquiry about the complaint made by the respondent. Exhibit P4 is reply notice issued by the petitioner to CPI Rural Police Raichur, wherein it is stated that the respondent has filed false complaint against him and his mother. Exhibit P5 is a copy of letter dated 21/2022 issued by the petitioner to Superintendent of Police Koppal, and it suggests that petitioner has sought police protection. Exhibit P6 is a certified copy of FIR in crime number 10 of 20 of Gangavati PS, and it suggests that the petitioner has filed missing complaint, wherein it is stated that on 21/1/2020 at about 3:30 p.m. his wife, the respondent, went out his wife respondent went out from the house and whereabout of her presence is not known. Exhibit P7 is certified copy of FIR in crime number 87 of 20, and it suggests that said criminal case is filed by the mother of the petitioner against the respondent and her mother, alleging that on 17/5/2020 at about 4 p.m. the respondent and her mother picked up quarrel with the mother of petitioner and pushed her in a water tank. Exhibit P8 is a certified copy of the order passed by Honorable First Additional District and Session Judge Koppal, dated 28th August 2020, and it suggests that respondent and her mother had filed bail application under section 438 of CRPC in crime number 87 of 20, and they have been enlarged on anticipatory bail. Exhibit P9 is a certified copy of FIR in crime number 120 of 21 in Gangavati PS, and it suggests that the present respondent has filed said case against petitioner, his mother and sisters, alleging that they have committed the offence punishable under section 498A and 506 read with 149 of IPC and under section 3 and 4 of Dowry Prohibition Act. Exhibit P8 is a certified copy of the order passed by the Honorable First Additional District and Session Judge Koppal, dated 16th day of August 2021, and it suggests that the petitioner, his mother and sisters had filed bail application under section 438 of CRPC in crime number 120 of 2021, and they have been enlarged on anticipatory bail. Exhibit P11 is certified copy of FIR in crime number 41 of 22 in Sirwar PS, and it suggests that the respondent has filed criminal case against the petitioner, his mother, sisters and relatives, alleging that they have committed the offence punishable under section 143, 147. Exhibit P12 is another certified copy of FIR, crime number so and so, and it suggests that present petitioner has filed counter case.
It is collapsed on all grounds.
My lord.
Marriage is collapsed. It's in a position where there is no possibility of patch up. It is beyond repair. So many complaints. I'm just saying, if you make a table.
Yes.
Too many. So it has strained itself such that we also tried. All of us, all the benches have tried to patch up.
I can understand, my lord. The thing is, my lord, at the time of filing MC petition, only 2 cases were there. That too filed at the instance of my lord very husband. One is missing complaint, another one is my lord for 307, alleging that my lord they tried to push the mother of.
Even suppose we were to reverse, what will happen? Let us assume.
My lord, if my lords are on that point, my submission would be, my lord, child born disabled. Child born disabled.
Correct.
And my lord, kindly, it is not their case also, my lord, that he has contracted, my lord, second marriage. It is because, my lord, he won, my lord, a case before the trial court, perhaps have instructions, my lord. He is not coming forward to join the petitioner.
We've tried many a time to settle by calling, but it appears it's gone beyond the point of bringing them together. That's why we took it up on hearing. So now only on merits for proceedings.
It is, my lord, all this, of course, my lord, prima facie, it goes to show that, my lord, there are case and counter cases. It is all because of this reason, my lord. It is at the one hand, they only, my lord.
Whatever it is, if really you wanted your husband, you would not have pushed it to this extent. How many cases? More than 10, 12 cases, OS.
It is either of the side, my lord.
Correct. The one side must always take the back seat, isn't it? You have to save the marriage. Somebody must take the back seat.
Now, why not it is husband, my lord, if that is the case?
That we don't have an answer. That we don't have an answer. It's only unfortunate, that's all.
Allah, my lord, kindly appreciate this fact, my lord. Parents, even parents is having another two girls, my lord. They also did not want this girl to be in their house. And my lord, sisters of respondent, they are all given in marriage, and they are staying with their respective families. And now the petitioner, even the father of respondent is also passed away. Now the mother and my lord, the respondent and is another brother, except my lord three, there are nobody. And much, my lord, muchly is argued on with regard to going before media and all. It is not so, my lord. It is not before the television media. For a moment, my lord, may I take lordship to petition filed by husband under section 13(1) 1A of Hindu Marriage Act. The pleadings may kindly be gone into, my lord, to establish, my lord, how he failed to substantiate the allegations. He has not sought any divorce on the ground of, my lord, multiple criminal cases registered against him. There are no pleadings in the petition.
There's no media report, is it?
No media.
CD produced.
That is, my lord. Why, my lord, may I make may I make one? May I give one clarification with regard to?
Yes.
These my lord, this wife has heard with regard to contracting second marriage. By this wife heard rumors, my lord, in the village that he is going to, my lord, marry some other lady. For that reason, my lord, she uploaded, my lord, one video clip on the social media. That's all, my lord. To avoid, my lord, that he is going to contract second marriage.
And that video clip, I am noticed, has been edited by in the social media. It's not about social media. He has not directly spoken, my lords. It's a news, my lords, run in the social media. It was edited and reproduced. Now the court has taken the cognizance for defamation against them, because it's a serious allegations were made. It's not about the. And one more thing, my lords, in the public, his brother came and assaulted. That offense is crime is FIR is also produced. Now charge sheet is filed.
What happened to all those trials?
No, charge sheets are filed, my lords. In all the cases, I inquired with him. And in 307, where his brother was assaulted him in the public, that is, my lords, charge sheet is framed. Now it is kept for charge, framing of charge. ಅವರು ಗೌರ್ಮೆಂಟ್ ಡಾಕ್ಟರ್ ಇದ್ರು. ಇದೆಲ್ಲ ಆದ್ಮ್ಯಾಗ ಅವ್ರು ರಿಸೈನ್ ಮಾಡಿ ಒಂದ್ ವರ್ಷ ಎಲ್ಲಿ ಕೆಲಸನೇ ಮಾಡಿಲ್ಲ. ಈಗ ಪಬ್ಲಿಕ್ ಈಗ ಪ್ರೈವೇಟ್ ಕ್ಲಿನಿಕ್ ಹೊರಗಡೆ ತೆಗೆದು.
ಅಲ್ಲ, ಇಟ್ ವಾಸ್ ಆಲ್, ಮೈ ಲಾರ್ಡ್, before filing petition itself, he say that he has
it's in a matrimonial dispute, my lords. It's arising out of emotions and relationships. We can't bring all the, my lords, through the evidence to create evidence and produce before the court every fact. But the conduct of the parties and other things, my lords, if the husband is refused to take back her, even I tried to convince him, my lords, because he is ನಾವು ಭಾಳ ಸಲ ಹೇಳಿದೆ ರೀಕನ್ಸಿಡರ್ ಮಾಡ್ರಿ ಏನೋ ಒಂದು ನೋಡ್ರಿ ಸಾಹೇಬರು ಭಾಳ ಹೇಳಿದ್ರು. Actually it was my lords, everyone others also requested.
Now, my lord.
Just a minute.
Yes.
Regarding the taking care of the child, what
Even
is
he has admitted, even cross examination ಅಲ್ಲಿ ಆ ಕ್ವಶನ್ ಕೇಳಿದ್ದಾರೆ, ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಕೋರ್ಟ್ ಮುಂದೆನೂ ಬಾರ್ಸಳ ಬಂದಾಗ ಇಲ್ಲಿ ಹೇಳಿದ್ರು ನಾನು ನೋಡ್ಕೋತೀನಿ ಅಂತ.
It is with the mother, my lord. It is with the mother.
Every time he has stated that, made a statement before the court also, this court.
And the husband is not even,
present order?
husband has not even filed.
Present order regarding maintenance?
There is no malords order.
DV
Act ಅಲ್ಲಿ ಅದು ಮೊನ್ನೆ ಅಮೌಂಟ್ ಎಷ್ಟೋ ಕೊಡ್ತಿದ್ದಾರೆ ಅವರು, ಅದು ಬಿಟ್ರೆ ಉಳಿದಿದ್ದು ಯಾವುದು ಮೇಂಟೆನೆನ್ಸ್ ಆಗಿಲ್ಲ.
My lord, kindly look at the conduct of husband, my lord. Even he has not filed any petition seeking visiting rights also. The child is always with the mother.
It's unfortunate, we agree, but we have to see on the merits of the
On the merits, my lord, except criminal cases, my lord, absolutely he has not.
That is only sufficient. Number of cases you can't even count.
Allah, that is there, my lord. Either of the side, from either of the side, it is there.
So I'm saying you can fight on the road only. You can fight, both will have one referee and you start fighting. beat each other. ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೊಬೇಕು. This is a family issue. We don't want to get into anything further. It is broken, it is irretrievably broken down. That's all we can say. So we have to decide on merits only. There's no midway, there's no chance of getting together. That's not in our hands. It's left to the parties. All the options have been exhausted.
Yes, my lord. If I followed lordship's, my lord, lordship's statement, but may I make this request, at least, my lord, for limited purpose, if matter it could be remitted back to enabling, my lord, the appellant herein to adduce evidence with a
one fact. And what's one more fact which your lordship's, it is initially filed before the civil court senior division at Gangavati. When it was at the stage of evidence of respondents, they filed CP before this court. On their request only, it is transferred and a specific date was given in the CP order and directed to dispose of the appeal mercy petition within 10 months. My lords. They did not appear. Then, my lords, we have taken the paper publication. Court has directed us to take the paper publication. After paper publication, my lords, then they appeared after several months. And now they are saying that no opportunity is given. In fact, they have exhausted their CP ಆಗಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಅವರೇ ಡೇಟ್ ತಗೊಂಡು ಅವರೇ ಬರಲಿಲ್ಲ ಅಲ್ಲಿ.
My lord, how my lord, evidence of respondent before trial court took as nil, my lord. It is based on the oral submission of a counsel stating that since, my lord, burden is on the husband and therefore he has he don't want to lead any evidence on behalf of respondent. That was the submission based on which, my lord, evidence is taken as nil. However, trial court, my lord, wrongly shifted the burden. If for limited purpose, if matter could be remitted back to the trial court, extending an opportunity, since it is a first appeal.
What will happen?
All that, my lord, I have instructions to say that, my lord, she never made an attempt to, my lord, kill the mother-in-law. And, my lord, she
Sujata is the mother-in-law, is it?
Sujata, yes, ma'am.
Just go to the wound certificate. Exhibit.
ಅದು ಎಷ್ಟೋ ಮಾರ್ಕ್ ನನ್ನ ಹತ್ರ
Exhibit, my lord. Lord, there are injuries, my lord.
So what is the exhibit number?
Exhibit. No, my lord, the said document is not marked. However, FIR and complaint mark ಮಾಡಿ.
ಇದರಲ್ಲಿ ನನ್ನ
Crime 87, my lord.
ಯಾವ ಎಕ್ಸಿಬಿಟ್?
ಎಕ್ಸಿಬಿಟ್ ಅಂತ ಮಾರ್ಕ್ ಆಗಿ ಅದ್ರ ಜೊತೆಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. FIR ಕಂಪ್ಲೇಂಟ್ ಜೊತೆಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅದು ಯಾವುದು ಎಕ್ಸಿಬಿಟ್?
ಅದು ಯಾವುದು
1075.
Crime number 87, my lord.
Crime number
87.
ಅಲ್ಲ 87307. 87.
You just show that wound.
Crime number 95 of 23.
ಯಾವ exhibit?
95 of 23.
87.
87.
No evidence was led by the respondent.
No, my lord. Oral evidence to that effect, my lord, to show that she was with the husband till, my lord, this crime number 87 is registered. Simanta was held, and, my lord, birthday of first birthday of a child was also celebrated.
She was filed on cruelty and desertion, or only desertion?
Desertion as well cruelty, my lord.
Both.
Yes, my lord.
Findings are on both.
Findings are on the both. And in 2 paras, my lord, findings with regard to cruelty is concluded. Only in 2 paras. Not referring to, my lord, all.
ಇಲ್ಲ ಅದು ಕೊಡ್ತದೆ ಅಲ್ಲ ಇಲ್ಲಿ ಒನ್ ಆಸ್ಪೆಕ್ಟ್
ಆಯ್ತು ಅದು ಒಂದ್ ನಿಮಿಷ ತೆಗ್ದಿ
ಅದರಲ್ಲಿ ಯಾವ ಬರೀ ಕ್ರೈಮ್ ಅಂತ ನಂಬರ್ ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ ಅದು ದಟ್ ಈಸ್ ನಾಟ್ ಪ್ರೊನೌನ್ಸ್.
We have to take a call on that. Otherwise, you can
ಸ್ಟಾರ್ಟಿಂಗ್ ಇರುತ್ತೆ.
We'll send it back, fix a time limit for respondents' evidence.
The one submission is evidence, my lords. What they are saying now is oral examination for additional evidence ಅಂತ ಕೇಳಿದ್ರು.
Whatever, let them leave.
ಅಲ್ಲ, my one request I can make, my lords, not about this issue. Only it will lead to continuation of further proceedings. And one thing may even your lordships also aware about the status of the parties and their mental status.
What do you say about this wound certificate?
Yes, my lord, wound certificate, I have submissions to say, my lord, accidentally she fell into the water tank, and moreover, my lord, for a moment, my.
How she could sustain the injury or no, this one contusion injury? She fell on the accidental fell. If it was accidental fall, how she can sustain a grievous injury?
I have videograph also, my lord. In fact, I should not disclose before this. Even both, my lord, both mother and my lord, this appellant has tried to rescue. If even I can display before the court also, that it is not their intention to take her life away.
Look at the nature of injury.
Yes, my lord. Even very
nature of injuries.
One
complete, my lord, falling into the tank is videographed by the.
Instead of rescuing her, why you are?
Yes, rescued. She is rescued.
No, we don't want to. Please restrain your.
Sorry. Sorry, my lord. I beg pardon.
One may, with lordship's kind permission, one submission.
Tell me.
One submission is that, my lords. Your lordships kindly see that conduct of both the parties, the registration of several crimes, because of the reason that now the relationship is been continued, and he is, my lords, matured enough to take a decision, appropriate decision in his life to lead life with her or not. Even I inquired 2-3 hours I sit together.
We are not suggesting anything.
ಅಲ್ಲ ಅದಕ್ಕೆ ನಾನು
We are saying to put it to a logical end. Now it has to be decided only on merits, isn't it? So what we are saying is, instead of simply here roaster after roaster and roasting the cake,
ಅದೇ ಅದು
no purpose will be served. Let it go to a logical end. What happens finally is happens.
House.
So what we could do is we could send it at that stage, fix a date, and say no time will be taken, no adjournment will be taken, and direct the court to expedite.
Yes.
So whatever the rebuttal they want to lead, let them lead. What else to do? And then finally, matter to be decided. Which year the
Like if the judgment is not set
2020.
aside, if the judgment is set aside, it will be not again leading the further evidence. My request is not pending appeal, even it can be done because there is a provision under the order 41 rule 23A. It can evidence can be taken because what they are saying is my lords, they have not let the evidence and the council has made a submission. ಈಗ ಫೈಂಡಿಂಗ್ಸ್ ಎಲ್ಲ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡ್ಬಿಟ್ರೆ and all that apart, my lords, even the issues were casted burden on us, and even other side also submitted that they have to prove the cruelty because I have went before the court. They are nothing to say that.
There are 22, my lord.
You were cross-examined, is it?
How we are 3 witnesses were cross-examined by three times, my lords.
Only
and there were documents were marked by on their side confronting us. And all that apart, my lords, kindly see their conduct. When they obtained the CP order, they did not appear.
Now, respondent evidence, what you want to lead?
My lord, evidence with regard villagers of my lord Sirwar and neighbors of Gangavati and my lord neighbor one
Any witness you want to examine?
only 3 to 4, my lord. 3 to 4. I have given list also, my lord. I have given list also.
They did not say, not satisfy my legal argument with respect to that, my lords. They have to satisfy order 21, order 41/27, my lords. Now they have come up with a plea that
Including including appellant here in my lord, other 4 persons
even application only why they are relevant for proving the, my lords. Now
No, what we are saying, what is the way forward? One is to complete the record. Now let's assume we were to affirm the judgment, and if it is challenged, then it may again come back to the same stage. So the alternative is, one is you permit them to file.
Keep pending of this appeal, my lord, that would meet the even because their evidence would be before your lordships to appreciate that whether they will overcome all these allegations or not.
I am not on that point.
Okay, we'll allow your IA. Let the matter go back. We'll fix a date.
Please.
We'll keep it pending. Let the court give a report.
Please.
But
The
no
6
theatrics-
witnesses, my lords, they have to come.
No theatrics of your client. You warn her.
Please.
No theatrics or drama.
No, my sorry. I'll advise.
And one submission.
ಆಮೇಲೆ ಅಲ್ಲಿ ಜಗಳ ಆಡೋದು, there is no place.
And
here only it's
ಅಲ್ಲ
difficult.
ಇದು ಆದ್ಮೇಲೆ ಮತ್ತೆ ಫರ್ದರ್ ಕ್ರೈಮ್ಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಬಾರ್ದು.
Lordship is well aware, my lord.
ಸ್ವಾಮಿ, one request.
Emotions are involved, my lord.
What to do?
Emotions.
We agree, but I'm saying finally in a court of law it will be decided
Yes,
on
yes.
the evidence on record. There is no point. See, once the mind is broken or shattered,
ಈ ಕೋರ್ಟ್ ಡಿಕ್ರಿ ಆದ್ರೂ ಇವನ್ ದ ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಕಂಜುಗಲ್ ರೈಟ್ಸ್ ಆದ್ರೂ ಮಲಾಟ್ಸ್ he is not willing because he is a person not he is educated and now only in order to comply legal formalities ಮಲಾಟ್ಸ್ now it has to be given the ಅದು ಬಿಟ್ರೆ ಅವರು ನಾವಂತೂ ಮ್ಯಾಕ್ಸಿಮಮ್ ಟ್ರೈ ಮಾಡಿದ್ವಿ ಚಿಕ್ಕವರಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು.
coming together is it's left to the parties. It appears it's not possible. For separation, they have to agree. They are not agreeing. So finally, court will have to pass some order.
Allah, my lord. Kindly appreciate, my lord. The rifting is not, my lord, so serious. It is only, my lord, due to.
We have called the parties. We have tried.
Yes.
All my brother has also called. We have also called.
Please.
So it doesn't appear that it can be done. So what remains is logical closure, for which noticing that no evidence was let in. On the IA we can allow.
ಅಲ್ಲಿ 6 witnesses ಬರ್ದಾರೆ. They have to confine.
Yes,
6 witnesses because they are in appeal and under 41/27. They have to satisfy the legal.
Limit the witnesses. You can't lead 6.
The 6 witnesses ಅಂದ್ರೆ they will again we have to know what trial ಆಗುತ್ತೆ.
You file a affidavit. How many you want to? Tomorrow we'll have it.
Please.
We'll have it on Monday. Out of these 6, what is on what point?
Yes.
You are going to examine.
Yes.
Only on this you any objection on IA 41 rule 27?
I will file formal objections because that does not satisfy the legal formality under order 4127.
In the affidavit,
You file affidavits of the proposed witnesses.
please,
Yeah?
affidavits of,
Of these witnesses.
please.
You file it.
Or they have to file evidence in the chief examination, in the form of chief
To
examination.
file the evidence before this court. Then we can send.
Outside. That is what the requirement, and thereafter this court will not consider whether it will be an.
Even lordships can refer, my lord, here itself before additional register for recording of evidence. That also can be done.
Yeah,
The counsel for the appellant submits that I under 41 rule 27 has been filed, and they may be given opportunity to produce oral evidence of the said witnesses, which may be necessary as respondent's evidence has been taken as nil before the trial. Nil antidya?
Yes, nil because of oral submission made by counsel.
To appreciate the merits of the stand taken in the application under order 41 rule 27. Affidavits of the proposed witnesses to be filed before this court. Relist the matter on.
Next week, my lord, because affidavits.
When? Tell us when.
Monday.
When will you file?
Next week. 25th, my.
25th. On 25th. No, we can keep it pending the appeal. You consent for instead of setting aside, we can keep it pending. You consent for it, we'll fix a time limit. We'll ask him to reduce.
Then I will get
instructions. Get instructions.
Any date may be fixed, mods, and that day we will close the cross examination also.
You file affidavit and documents in support of the affidavit. Most will be oral. I don't think any documents.
Yes, documents are already, my lord, marked during the course of. Yes.
There are several documents.
I only sought oral evidence.
Only oral evidence.
Oral.
File the oral affidavit.
Yes.
And a memo that it's only going to be oral evidence.
Yes.
You file a memo along with these affidavits.
Please.
You get instruction. We will send it back only for that limited purpose.
Please.
Let it be evidence and then a letter report will come.
Yes.
You get instruction. Relist on 25th.
Great.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ನಿಮ್ಮ ಆಪೋಸಿಟ್ ಇದ್ರೆ ನಾವು ನೋಡ್ಬೋದು ಆಪೋಸಿಟ್ ಬರ್ಬೇಕಲ್ವಾ
ಅದೇ ಇವತ್ತಿಲ್ಲ
ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ ಕೊಡೋಣ ಬಟ್ ಅವ್ರು ಬಂದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳಿ ಕರ್ಕೊಂಡ್ ಬಂದ್ರೆ ನೋಡೋಣ
ಅದೇ ಸರ್ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ತಂದ್ರೆ ಅಂತ
ಅಲ್ಲ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ 25th ಬಟ್ ನೀವು ಅವ್ರಿಗೆ ಹೇಳಿ
ಅವ್ರಿಗೆ ಹೇಳ್ತೇನೆ
ಬಂದ್ರೆ ನೋಡೋಣ
ಅದೇ ಸ್ವಲ್ಪ ಯಾಕಂದ್ರೆ ಲಾಸ್ಟ್ಗೆ ಅದ್ರ ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ ಸ್ವಲ್ಪ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಅಥವಾ ವಿತಿನ್ 10 ಆಫ್ ದಿ ಲಿಸ್ಟ್
ಕರೆಕ್ಟ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ನಾವು ವಿ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ 25th ನೀವು ಅವ್ರಿಗೆ ಒಂದ್ ಮಾತು ಹೇಳಿ ನೀವು ಬಂದ್ರೆ ತಗೊಂತೀವಿ ರೀಲಿಸ್ಟ್ ಆನ್ 25th ನೀವು ಅವ್ರಿಗೆ ಹೇಳಿ ಅವ್ರೇನಂತ ಬಂದ್ರೆ ನೋಡೋಣ